Can schools censor student speech that promotes illegal drug use? What authority do schools have to regulate student speech that contradicts the educational goals of the school? Jamie, how do you usually celebrate your one-year anniversaries?
Well, in honor of Chalk and Gavel's one-year anniversary, we're going to go back about 20 years to cover a classic case, everybody.
I'm so excited about this.
I know, this is a great case. It's a lot of fun. This is a landmark Supreme Court case, at least until the Brandy Levy case came along. It was the court's most recent student speech case. The Brandy Levy case we covered in episode 3.
Right.
That was the cussing cheerleader case, right?
Yeah, this is one of like the top 4 student speech cases because really there's only been 4 or 5, right?
Yeah, there's 4 or 5, and this is one of them, and we're going to talk about it today. So this is Morse versus Frederick, or as most of us call it, this is the Bong Hits for Jesus case, everybody. Yay.
Unforgettable.
Yeah, I know. So stick around as we head up to Juneau, Alaska as the 2002 Olympic torch heads through the town and high school students are allowed to go check it out as it passes by. And as it passed and the TV news cameras started rolling, we have high school senior Joseph Frederick and his friends. They hold up a 14-foot banner that says, you guessed it, Bong Hits for Jesus.
It's so perfectly high school. It's so perfectly like 2002. This case just really, there's so much fun stuff in this case.
There's a lot of good stuff in this case. So stick around, folks, and we're going to dive into it after we do our bell ringer, like usual.
Yeah. Been doing this for about a year. I think people know what to expect. Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So speaking of bell ringers, Jamie, do you have our bell ringer for this week?
I do. Yes. So this is an article that is in Ed Week, and this is an article from our good friend, Mr. Mark Walsh, who we're going to see in a couple of weeks when we are all down in Orlando for the Education Law Association annual conference, everybody.
Yeah. He gives a keynote at the end of the conference that does a Supreme Court update, and it's always one of the highlights of the weekend.
Yeah, it's always a lot of fun. So Mark wrote this article. This was back at the end of September, and this is kind of a follow-up from our episode 14 from back in March. So that was the Coalition for TJ versus Fairfax County case. And we talked about how a magnet school changed its admissions policies to boost underrepresented minorities. And the policy was challenged on behalf of Asian American families whose enrollment in that school declined. Okay. And in that case, a federal appeals court said that the new policies were race neutral, and they ended up upholding the new policy. And in February, the reason why we covered that case back in March was because in February, the U.S. Supreme Court declined to take up that case, which left that lower court's opinion in place.
Right. And there was that opinion from Alito, I think it was, where he said he would have taken up the case because he didn't like the outcome.
Yeah.
So we were kind of thinking about like, this is coming down, that there's going to be something here eventually.
Yeah. So we're going to be hearing that guy's name quite a bit today.
Yeah. He wrote one of the opinions in Morse v. Frederick.
Exactly. So, so that was the TJ, the Coalition for TJ versus Fairfax County case. And the article that Mark wrote at the end of September was about a very, very similar situation that is taking place up in New York. This case is called Christa McAuliffe Intermediate School PTO versus de Blasio. So in this case, we've got 9 selective high schools in New York City, and there's something called the Discovery Program, which has been around since like the 1960s, that creates this kind of pathway for admission into these 9 elite schools, okay? And while a lot of students are admitted through an entrance exam, this Discovery Program is designed to give opportunities to disadvantaged kids, okay? And in 2018, the program was expanded to increase the number of Black and Latino students, and it set aside 20% of the school's entrance seats for those disadvantaged students.
Okay.
So the requirements for this program, or for admission rather, look a lot like the Coalition for TJ case that we covered, right?
Right.
And so one of the things was they created this metric to determine whether or not the feeder middle schools were serving disadvantaged communities.
Okay.
And so that very similar to the TJ case as well.
Yeah. Yeah. It sounds very similar, where we've got these elite magnet schools, which aren't representative of the communities.
Mm-hmm.
Community gets concerned about that, tweaks the admission process, but then that has the outcome of
a decreasing number of Asian American attendees to these schools, or a number of Asian Americans who will qualify for a space there.
Sure.
And so some Asian American advocacy groups and parents challenged this similarly under the 14th Amendment's Equal Protection Clause, and a federal district court found no disparate impact and granted the city's request for summary judgment. So similarly to TJ.
Right. That's how the TJ court came out too.
Right. And remember, that decision stood because the U.S. Supreme Court, they declined to take up the case.
Right.
Right. And so this federal district court ruled similarly in New York. But at the end of September, the Second Circuit Appeals Court revived the lawsuit. Okay.
Right. Okay.
And there are some technicalities in what they said, but they basically said that it was something about the discovery process, and they ruled the original ruling was a limited sort of assessment of discriminatory racial impact. And so they said that this program could have been adopted with discriminatory intent.
Right.
And therefore, this should be able to move forward. And the Asian American students who were indeed harmed, which is what the court said, should be allowed to proceed and have the opportunity to prove that this was a discriminatory policy.
Okay.
And that the intent was discriminatory in nature.
Yeah.
So basically, the reason why, I thought this would be a good bell ringer is because it's very similar to the TJ case, but now they're looking at it again in a different district court. And so between the TJ case, this case, and there's another case pending appeal out of Boston that is pretty much identical, has to do with Asian American students' enrollment at elite schools. We might end up seeing a mess that the U.S. Supreme Court is going to have to take up, right?
Right. Well, we've been saying that about a lot of issues, and the Supreme Court has been kind of reluctant to take on some of these educational issues just because they're so complicated and ideologically charged. But this is kind of what we saw with affirmative action at the higher ed level, where the court took up these higher ed affirmative action cases, ended up upholding affirmative action for a long time. And then we saw a K-12 affirmative action decision a few years later that came out differently. And then obviously the Supreme Court recently kind of reversed course and found that affirmative action policies weren't in accord with the 14th Amendment. So, it's only a matter of time, I think, before we see a K-12 race-conscious admissions or even these, which are not explicitly race conscious, right? Like that's the thing about these policies is they are looking for ways to increase racial diversity, but doing so in race-neutral means.
Race-neutral ways,
maybe
yeah.
they're not even trying to increase racial diversity. Maybe they're trying to increase socioeconomic diversity
Right.
as well. But because the United States, there's a lot of overlap between those two things. So like,
Mm-hmm.
I think one of these cases is going to get to the Supreme Court eventually. It's just going to be a question of which one. But like the TJ thing, the court there was really worried about this idea of how do we determine discriminatory impact? Is it a before-after test? Is it something else?
Uh-huh.
And I think like that was kind of Alito's big critique with that case. So this all comes down to, are these motivated with a desire to like discriminate against Asian Americans or with this impermissible racial intent? And then discriminatory impact has traditionally been treated as a piece of that puzzle that
Right.
helps us determine if there was a discriminatory intent. Because most people, when they pass laws that are discriminatory, don't come out and say it. So you have to kind of look at the circumstances to see if there was an intent to discriminate.
Okay.
And so like, we'll see how these go, but I think it is definitely going to get to the Supreme Court at some point, probably sooner rather than later.
Yeah. All right. Well, we'll follow it. We'll keep you updated. Shall we get into some bong hits for Jesus here?
Let's do it. Yeah, I've been wanting to do this case since we started Chalk and Gavel, so I'm glad we're getting to it.
Well, here we go. Happy anniversary, Chris.
Yeah, exciting. 1 year. Look at us.
Okay.
What is that? Cotton? No.
I don't know.
Paper. I think 1 year is paper.
Okay.
It's the paper anniversary. I didn't get you anything. I'm sorry.
Oh.
Well, this is also our second marijuana case in a row, which was not planned.
Oh, is it? Yeah, I guess it is.
Yeah. But we're not talking about crumbs in this one.
Okay, well, let's just get into it. Let's see what happens here. So remember, we are in Juneau, Alaska. This is 2002. It's the run up to the 2002 Winter Olympics that were going to take place in Salt Lake City. And on January 24th, so, roughly a month-ish or so before, less than a month maybe before the Olympics, the torch is doing its rounds, right? Like it's not on its own, like it's being held by somebody. But
Typically.
So it's, the Olympic torch is kind of going all through the country and everything. It's making its way through Alaska, and it was going down Glacier Avenue because there's,
because Alaska.
because it's Alaska. So it's making its way down Glacier Avenue, which is runs right in front of Juneau Douglas High School. Okay. So this is a big deal. Like, especially, I don't know, like I remember being in high school or being around that age. And like if the torch came through your town, like that was a big deal.
Oh yeah. Like the pageantry of the Olympics and the person running, holding the torch, the torchbearer. Like, it's basically a parade, right?
Yeah. Totally. So, like, of course, it's going through town and, the media is out there and all that stuff. And it's a big deal. And so the school administration at Juneau Douglas High School recognized that it was a big deal. And they decided to allow students to leave classes and go out and watch this torch go by. Okay. Nice little,
diversion, right?
Yeah. Nice thing to do for the students. Something big that's happening in the city. So everybody was there. Students went out there. There were lots of community members out there. The school's pep band was playing. There were cheerleaders out there in their uniforms. There were other sponsors that were out there to celebrate the torch going through. Coca-Cola. They were handing out free samples of Coke in plastic bottles and everything. And the students were getting a little rowdy.
I was going to say, this sounds like a party, right?
Yeah, this is like everything that I'm describing here is like, these are the things that encourage high school students to have as much fun as they can have, right?
Right. Yeah. That's a fantastic way to put that.
Yeah. So they're throwing these Coke bottles at each other, right? There's snowball fights going on because, hey, Alaska in January.
On Glacier Avenue.
On Glacier Avenue. It was reported that even other students even got into an actual fight there. So mass chaos, dogs and cats living together.
Right, yeah. Because you got to imagine these students are waiting patiently for the Olympic torch to go by, right?
Yeah. And patiently, right? So at this point, unbeknownst to the school administrators, high school senior Joseph Frederick arrived, and he stood with some other students on the other side of the road across the street from the high school. He didn't go to school that day. He said that he got stuck in the snow in his driveway and he couldn't make it out in time because, hey, Alaska.
Right, yeah.
This is nothing against Alaska. I have never been. I've always wanted to go. I hear it's incredible. One day I will go.
Field trip.
But
we talked about that when we did our Hawaii case too. So I think we'll just add this to the field trip list.
Okay, sounds good. So again, Frederick didn't go to school that day. He just showed up for all the festivities.
Yeah,
all right.
Come for the fun.
And so what happened was, right as the torch was going by and the TV cameras started rolling in that area.
A crucial detail.
Yes, exactly. Mr. Frederick and his friends held up a 14-foot banner that said, I mean, we gave it away at the beginning of the episode, Bong Hits for Jesus. All right.
So I've actually seen the actual banner. It was on display at the museum in DC.
Oh, in DC. Yeah.
And so when I did a summer with the Department of Education, and I went to the museum, and I just turned a corner, and it was right there. And
that's
I've
awesome.
been studying it. It's big. 14 feet long, 3 feet wide. And it's that big kind of white paper that you get in schools.
Yep.
And it's just Bong Hits for Jesus written on it in duct tape. So it's strips of duct tape spelling out Bong Hits for Jesus on this white paper. So it is.
And it's the number 4, by the way. It's not FOR. It's Bong Hits number 4, Jesus. Maybe they were just trying to conserve space, or
well, it looks like they wrote Bong Hits and then realized they were running out of space.
It's a classic problem. Yeah, and you can go online and you can search for, Morse versus Frederick or Bong Hits for Jesus or whatever, and click on the images and it'll show
Bong
up.
Hits for Jesus.
Yeah, it's like 3 feet tall, 14 feet long. It's big.
And there's like 8 or 9 students holding it up at least.
Yeah. Well, it's a big sign.
It is.
Yeah. So let's take a second here and talk about what Bong Hits for Jesus means, Chris.
Yeah, that's a great question. Right, because there's a lot of it. So, maybe we should start with what Frederick intended it to mean, right?
Was he encouraging religious figures to take up illegal drug use?
Well, I don't think he wants Jesus to take bong hits. The meaning of this sign is something that the courts are actually having to grapple with and fight about, right? So there's a couple ways you can understand the sign. It could be a command. It could be saying, hey, you go take a bong hit or multiple bong hits for our Lord and Savior, Jesus Christ. That is one way of reading it. Another way is
because that's what he would want us to do.
Right. Yeah. Another way to read it is kind of celebrating illegal drug use, bong hits for Jesus. It's a celebratory thing. Let's all go do bong hits.
It will be a religious experience.
Right. Even the courts are kind of saying this is nonsensical. It doesn't mean anything.
I mean, you could move the order of the things around and it would be more interesting. It could be 4 bong hits. Jesus. Jesus. 4 bong hits?
Oh, I like that.
You like
That's
that one?
good. Yeah, because what does that even mean? I mean,
well, I was
we don't know what any of this
take
means.
Take it easy,
yeah.
buddy.
Right.
Slow down on the bong hits.
Well, yeah. And
sorry, this is...
it's one of those things where if you change any of this, the whole case changes, right? Because imagine if it said no bong hits for Jesus.
Oh yeah, then the message is completely different.
Now is it discouraging illegal drug use?
Right.
Probably no more than it was originally encouraging it, but I think it is a very intentionally chosen message because it doesn't really mean anything, but it seems to be incredibly provocative.
Yes.
Right. And I think that's
that seems to be what we're going for here.
Right. How do I get
Mr.
two
Frederick?
of the most controversial things in the early 2000s onto one sign?
Well, that's how.
Exactly. Bong hits for Jesus.
With some duct tape. So this was a big case. And so, there's a lot of media around this case. And so in an interview later on, Frederick explained, quote, I conducted my free speech experiment in order to assert my rights at a time when I felt that free speech was being eroded in America, unquote.
I love that phrase, free speech experiment, because to me, that really kind of captures his motivation.
Exactly.
And I think later on, or in one of the court records, it says that Frederick had been told by an assistant principal that like, hey, you don't have First Amendment rights. And he knew that that was wrong because of Tinker and all these other cases that we've kind of mentioned already.
Mm-hmm.
So like that idea of this being a free speech experiment, he wanted to, basically he's testing out whether or not he has rights. I think that's really cool.
Yeah. He went on to say, quote, "The high school I attended advocated that the Constitution and the Bill of Rights did not apply to students," which was interesting. He said, "I was skeptical of my own free speech rights, and I wanted to know more precisely the boundaries of my freedom."
Yeah.
Mm-hmm.
Yeah.
And
So going back to that idea of this being an experiment.
yeah. And so he said, quote, "The phrase Bong Hits for Jesus was never meant to have any substantive meaning. It was certainly not intended as a drug or religious message. I conveyed this to the principal by explaining it was intended to be funny, subjectively interpreted by the reader, and most importantly, an exercise of my inalienable right to free speech."
Yeah. And it was also really like provocative. And there was a television camera.
Yeah.
So maybe part of it might have maybe been
Yeah.
to get on TV.
Yeah. But like, I don't know if he would admit that.
Right.
So, I mean, there's some other things that happen that we'll tell you about that kind of seem to help reveal Frederick's character and disposition or intent or whatever.
Let's say his flexible relationship with authority.
Yeah. Yeah. Okay. That's good.
No, because like, and I think Frederick, what he's saying here seems to suggest that he's comfortable pushing the boundaries of authority because he just kind of wants to see where they are, right? Like, where do his rights stop and the legitimate authority from the school start? So like, to me, he's kind of doing what like all adolescents do, which is
that's what I was just
push
going
the
to say.
boundaries,
like,
right?
It's like, you're trying to figure out where the boundaries are, and he's a senior in high school, and he's doing it with a very sort of sophisticated topic, right?
Yeah. And I think like, this is a level of sophistication for testing your rights that like at a school event, potentially a school event, we'll talk about that in a second, where there's going to be national media attention.
Mm-hmm.
And they got this perfect sign, Bong Hits for Jesus. And like, it creates a constitutional question that gets all the way up to the Supreme Court. Like,
So here, let's talk a little bit about what happened after the banner went up.
Right. Yeah. Because
it came down pretty quickly.
Yeah. Imagine the scene. There's national television cameras. You as a school administrator see your students put up a banner that says Bong Hits for Jesus.
Right. And remember, he's on the other side of the street. So the banner is facing the school, right? Where everybody has come out. The administrators and the students who were at school that day came out, and they're all like facing him. So anyway, Deborah Morse, who is the principal, crossed the street and demanded that Frederick and the others put the banner down, and Frederick said no. And when he was confronted, apparently he said, "What about the Bill of Rights and freedom of speech?" And Morris was not really interested in engaging in that conversation.
Probably not at that moment, no.
No, because she grabbed the banner, she crumpled it up, and she told Frederick to report to her office. Okay, so why did she take down that banner?
Well, I think it seems pretty self-evident.
Yeah. So she later testified that she felt, quote, that it violated the policy against displaying offensive material, including material that advertises or promotes use of illegal drugs, unquote. The Juneau School Board policy stated, quote, "The board specifically prohibits any assembly or public expression that advocates the use of substances that are illegal to minors," unquote.
Okay.
So we've got a board policy that very specifically says no public expression that advocates the use of illegal drugs. And
which
Morse
Bong Hits
testified
for Jesus
seems to do, right?
Maybe,
possibly.
Uh-huh.
The interesting thing here, one of the interesting things here is that most freedom of speech cases with students in schools up until this point, for the most part, have to do with the Tinker standard. We talk about the Tinker standard all the time, right? And that's the sort of disruptive
material and
standard.
substantial disruption, right?
Right? And so if speech doesn't cause a material and substantial disruption, or if you don't have a legitimate reason to believe that that disruption is going to occur, then you've got to be a little bit more hesitant about restraining speech.
Right.
Okay? There were other cases that came along, Bethel versus Frazier, for example, the Hazelwood versus Kallmeyer case that sort of provided a few more sort of goalposts around student speech. But for the most part, it's this disruption standard that is a huge speech criteria, right?
Right. Yeah. Typically, unless it falls into the Hazelwood exception or the Bethel v. Frazier exception of lewd and indecent speech,
right?
Tinker is the
gold standard.
Exactly. So if it doesn't create a material and substantial disruption, schools typically have to allow it. And here, she doesn't say anything about a disruption.
No, she said it exactly. She said it violated this board policy about advocating for the use of drugs. So she didn't bring up the disruption piece.
Right. And nobody does throughout the entire case because they couldn't point to a disruption. They actually they didn't put on any evidence of a disruption.
No, it sounds like there was plenty of disruption already occurring there that had nothing to do with that.
Exactly. Yeah.
Sign, right?
Right.
So what the school argued was, quote, display of the banner would be construed by many, including students, district personnel, parents, and others witnessing the display of the banner, as advocating or promoting illegal drug use, which is inconsistent with the district's basic educational mission to promote a healthy, drug-free lifestyle. Failure to react to the display would appear to give the district's imprimatur to that message and would be inconsistent with the district's responsibility to teach students the boundaries of socially appropriate behavior.
Interesting.
So that is the argument that the school made.
And to put that into I guess, peel back the curtain a little bit, the imprimatur language, basically they're worried that people are going to see this message and be like, oh, that school is promoting illegal drug use.
Yes. So they felt like they had to
take
something.
It down. Right. And that idea of school-sponsored speech is what the Hazelwood case was all about.
Right.
And then this other thing about teaching students the boundaries of socially appropriate behavior, that's straight from Bethel versus Frazier, which was the case of the lewd and indecent student speech at a school assembly. So you can see them kind of marshaling their arguments.
Yep.
But they're clearly not relying on Tinker.
Correct.
I don't know how much I buy the argument that people are going to think that the school is cool with Bong Hits for Jesus if they don't respond. Because it's students standing on a street holding up a sign. There's nothing to indicate that they're speaking on behalf of the school.
Right.
I always hesitate with that argument.
I see that. So let's go back to Frederick here. So Frederick was told by Morse to go to her office. And does Frederick go to her office? No, not right away.
I was going to say, what I know of him so far, probably not.
No, he's like, you know what? I'm going to see how far I can go with this one too. So he gets his books out of his car. He goes to class. And at some point, he goes down to Morse's office.
Right. It sounds like a kind of a power play move, right?
Yeah. I feel like my rights were violated, so I'm not going to go out of my way.
Right.
To listen to authority here.
Yeah. And there's some disagreement here too, because later the court is this is kind of an open question, but it doesn't really matter. It's just an interesting part of the story because Frederick's version is that he got his books, went to class, put his books down, and then went to the office because, he wanted to make sure he was ready for the school day. Whereas Morse, the principal, says, I had to track him down eventually because he just refused to come to my office.
Yeah.
So it's just an interesting wrinkle to the story.
Mm-hmm. So when he was in her office, Morse asked Frederick to give her the names of the other students who held up the banner. And knowing what we know about Frederick, do you think he gave up his friends?
Oh, absolutely not.
No, he did not.
Noticing a pattern.
Yeah, exactly. So Morse decided to just suspend Frederick for 10 days. Frederick's version was that Morse was only going to suspend him for 5 days until he quoted Thomas Jefferson on freedom of expression, which caused Morse to increase it to 10 days. I
can't, I love picturing this scene where he's got all of these statements about the importance of freedom of expression and how it relates to education. And he's just engaging in this very high level intellectual exercise around the banner, Bong Hits for Jesus. And the principal is just I don't care.
I don't care. You're suspended. So Morse claimed that the extra days were added because he refused to name the other folks who held up the banner. And he claims that it was because he decided to argue about his rights. So after Frederick's suspension, the school experienced some pro-drug graffiti that the principal thought was sparked by the banner. This is really the only evidence that there was any kind of potential disruption that was caused by this speech. But, I guess this didn't really gain much traction. It didn't last too long.
Yeah, and
whatever.
There's no other evidence of disruption. So
Right. So then we've got Frederick, who obviously we've established is rather well informed about his rights, or at least what he thinks are his rights, right?
Mm-hmm.
So he decides to appeal the suspension to the superintendent. The superintendent looks over everything and decides to uphold the suspension. And according to the superintendent, the punishment was appropriate because displaying the sign conflicted with the school's mission, and Frederick engaged in defiant and disruptive behavior in displaying the sign, refusing to take it down, and refusing to name his accomplices. So at this point, he had already been suspended for 8 days. And so the superintendent decided that that was enough and limited Frederick's suspension to time served. So he was suspended for 10 days. He appealed, and everything sort of played out by the 8th day. And the superintendent said, all right, that's fine. You're done. Okay.
Yeah.
So in making that decision, the superintendent concluded that Frederick had displayed his banner, quote, in the midst of his fellow students during school hours at a school-sanctioned activity, unquote. And as to the meaning of the banner, the superintendent said, the common sense understanding of the phrase bong hits is that it is a reference to a means of smoking marijuana. This guy's on top of it, man.
Well, that's part of the fun of this case is just
I know.
Watching Supreme Court justices.
He's like, so you got to explain, like, bong hits means smoking marijuana.
Yeah, right. It's like,
thanks, buddy.
It's kind of like when the justices were talking about emojis. You're just like, yeah, we get it. Keep going.
So he also said, given Frederick's inability or unwillingness to express any other credible meaning for the phrase, that he can only agree with the principal and countless others who saw the banner as advocating for the use of illegal drugs. He didn't consider Frederick's speech political. He was not advocating for the legalization of marijuana or promoting a religious belief. This is according to the superintendent. He was displaying a fairly silly message promoting illegal drug use in the midst of a school activity for the benefit of television cameras covering the torch relay. Frederick's speech was potentially disruptive to the event and clearly disruptive of and inconsistent with the school's educational mission to educate students about the dangers of illegal drugs and to discourage their use. So,
okay.
Yeah, he kind of throws in the disruptive piece in there, but he doesn't toss out sort of the other argument about this is promoting illegal drug use.
Right.
He's basically saying there's really no other way to look at this message as it's about drugs and it's not political in nature, advocating for the legalization of marijuana or anything like that. It's just a silly, provocative thing.
Yeah. Well, right. And we'll talk about like different versions of the sign and whether those would be constitutional or not. Because if it said like legalize bong hits for Jesus, I think we're in an entirely different camp, right?
Yeah.
But what I find really interesting about the superintendent's comments here is this idea of it being inconsistent with the school's educational mission. So basically, he's making the argument that the school has, as part of its educational mission, it wants to teach students about the dangers of illegal drugs. It wants to teach them not to do drugs, right? Just say no. And then the speech advocating for the use of illegal drugs, if that's how you interpret the sign, clearly contradicts that. And so they're saying because it contradicts our educational mission, we ought to be able to silence it.
Yes.
And I think that is a really problematic argument because it's viewpoint discrimination, right? Like if the sign said bong hits for Jesus, maybe the principal's argument, like that's the argument the principal's making is that contradicts their educational mission. But if it said no bong hits for Jesus, is he going to still take the sign down? Because now that's in a agreement.
That's in accordance with their mission.
Exactly.
Right.
So like it's clearly viewpoint discrimination and
but it would still be considered, and that's the interesting thing, because it would probably still be considered by many as a silly sign, a silly or provocative sign, even if it said no bong hits for Jesus.
Right.
Like that's kind of different than saying, drugs are bad. Okay.
Exactly.
Don't do drugs or say no to drugs. If he just held up the Nancy Reagan banner. Was it Nancy Reagan who was just say no
Just
to
say
drugs?
no. I think that was her.
Okay. So anyway, if he held up a banner that said, just say no to drugs, that's very different than a banner that says, no bong hits for Jesus. But essentially, it's kind of the same message.
Exactly. Right. And I think that's why I'm super skeptical of that argument. And it'll play out in the courts, and we'll talk about kind of how the courts deal with that argument as well. But just to kind of raise it here for kind of understanding why the school is at least saying what it's saying. Because really, if I'm the principal and I'm dealing with this and I see that sign go up, and this actually goes to something that we've talked about a lot, it's so important to know the law and to know your school policies. The principal, there was a policy against promoting illegal drug use. So she followed her policy, right?
Mm-hmm.
And whether or not that policy was constitutional,
right?
That's a question that gets all the way up to the Supreme Court. So there's no way for her to know in that moment that what she's doing does or does not violate Frederick's rights, because, to give a little bit of a spoiler, 5 justices said it didn't violate his rights. 4 would have said, maybe it did.
Right.
And so it's so important here. This is kind of why we have qualified immunity, which we'll talk about in a second, to give people like Morse the ability to do their job in the moment. Because you got to imagine the calculus that was going through her head in that moment was not, do I have reasonable suspicion of a material and substantial disruption?
No.
Right? It was, oh my gosh, this
There's
sign
a
is going to be
sign
it's going to be on the evening news, and it's going to look really bad for my school.
Right.
I need to do something about this because that's not what proper behavior dictates.
Right.
Right. That's what's going through her head.
Yeah. So how it got to the Supreme Court basically was Frederick was not happy with the superintendent's decision and appealed the suspension to the school board. The school board upholds the suspension, and obviously he doesn't like that either. So he files a lawsuit.
Files a lawsuit against the principal and against the school board. Files his lawsuit on April 25th, 2002. So, only a couple months have gone by at this point. This is moving pretty quick.
Mm-hmm.
It stops
until
moving
now.
Quick.
Yeah. Yeah, it hits the courts.
Right. And it slows down pretty significantly.
Yeah.
So Frederick brings this lawsuit in the U.S. District Court for the District of Alaska. And he's basically arguing that the principal and the school board violated his free speech rights under both the First Amendment to the United States Constitution and under the Alaska Constitution.
Okay.
And so he's asking for a whole bunch of relief. He wants a declaratory judgment that they violated his rights. He wants an injunction to basically take off his suspension. And he's asking for compensatory and punitive damages. So asking for a lot, but the general gist of it all is that they violated his free speech rights.
Okay.
So at this point, we've got our lawsuit, and that's when the motions start flying. And so we're at the trial court level. We kind of gave it away already, but this gets all the way up to the Supreme Court. So at the trial court level, the school defendants move for summary judgment based on the grounds of qualified immunity. And Frederick, for his part, files for summary judgment and says, I win as a matter of law. So the court's looking at these cross motions for summary judgment, and we've talked about qualified immunity a lot. We've already mentioned it today, but it essentially protects governmental officials who are performing discretionary functions from liability for civil damages as long as their conduct does not violate clearly established rights of which a reasonable person would have known. And so, like I said earlier, to kind of give them a sphere of discretionary authority to basically act in what they see as kind of the best interests of the organization, as long as they're not violating someone's right that is clearly established that a reasonable official would know was constitutional.
Right.
Right. So that's kind of the issue here is this a clearly established right that would be clear to a reasonable official that the conduct was lawful under the circumstances?
Right.
So for qualified immunity, you have to answer 2 questions. Was there a constitutional violation? And if there was the right clearly established?
Okay.
So the trial court starts with the second question first. Was Frederick's right to hold up his Bong Hits for Jesus banner clearly established? And this is where kind of the big argument comes in for this case is kind of which bucket do we put this in? Do we put Bong Hits for Jesus into the tinker bucket and say you can't prohibit it unless you have a clear and material and substantial disruption? Or do we put it into the Bethel versus Frazier bucket and say that
It was lewd or offensive or
It was
indecent.
lewd, indecent, offensive.
Yeah.
It undermined or contradicted the school's educational mission.
Right.
Right. And so that's kind of the big argument here is because if it's under Tinker, then like, yeah, this is clearly established because we've had Tinker since 1969.
Exactly.
But if it's in the Bethel bucket, then maybe it's not clearly established because Bethel didn't say anything about illegal drugs.
Right.
It's just said, you know, lewd, indecent.
Yeah. So it's not clear that this message would fall into a lewd or indecent or offensive
Right, exactly.
category.
So
That's
it's not clear that illegal
established.
drug use or messages advocating illegal drug use are or are not protected under Bethel.
Yeah.
Right. And that's kind of what the district is arguing. They're arguing that this ought to fall under the Bethel versus Frazier. And if it falls under the Bethel versus Frazier, then the exact contours of that as it relates to promoting illegal drug use are unknown. So this is a not established or not a clearly established right. And that's ultimately what the trial court goes with. It finds that Frederick's rights here to hold up a banner promoting illegal drug use in violation of school policy was not clearly established. So they're kind of, as we'll talk about more in a second when we talk about the substance of the complaint, the trial court here is putting this much more in the Bethel bucket rather than the Tinker bucket. And so that is enough to decide the immunity case, right?
Yeah.
Because whether or not you violated a right doesn't matter if the right isn't clearly established.
Right.
But the trial court doesn't stop there. They actually look at whether or not there was a constitutional violation here, whether or not Frederick's free speech rights were violated at all. And so there's a couple questions we kind of have to answer before we can even get to that. The first is, was this a school-sponsored activity?
Okay.
Because there's language in Bethel versus Frazier that kind of says if the student there, Frazier, had given that speech outside of school, it would have been protected. So if we don't see this as school-sponsored speech, then it's almost guaranteed to be protected speech, which means it would be a violation of his free speech rights to force him to take the sign down. But if we do see this as school-sponsored speech or as speech that occurs in the school environment, then Tinker and Bethel would apply and potentially this is not protected speech. So the court looks at all of this and says, yes, this was a school-sponsored activity. So it was speech within a school-sponsored activity because, yeah, you dismissed all the kids from school, but that was because the school dismissed them. It was basically
It was to do this. It was to go to that event.
Right. There's educational benefit here.
Yeah.
This is, the school was there. They were supervised. Whether or not they were tightly supervised or not is an open question. The band was playing, the cheerleaders were there. Like this was clearly, it was during the school day. Like all of those things kind of indicate that, yes, this was a school activity. And regardless of whether or not Frederick was there at the beginning of the day, he did arrive at this event, which was a school-sponsored activity. So he's under the responsibility or under the auspices of the school at this point.
Okay.
So then the fun part. Do we put this into Tinker or do we put this into Bethel versus Frazier? And the trial court says this one goes under Frazier.
Okay. If you have to choose between the two, I can see how they made that decision. I can see it. I'm not necessarily saying I agree with it.
Right. I'm in the same boat. I see it.
Yeah.
I don't agree with it.
Yeah.
But they put it into Frazier because this isn't really political speech like the armbands in Tinker. And it is more akin to the lewd and indecent speech of Bethel because that speech was punishable because it violated the school's mission of like teaching decorum and teaching like proper forms of address. And so the court says, well, the board has a policy against promoting illegal drug use. This promoted illegal drug use. That's almost identical to what happened in Bethel.
Because Bethel was a student that spoke very inappropriately at a school assembly.
So we got to cover that case too, because that's also a really fun case.
That's a good one. That's a fun speech to read.
Oh, yes. I'll make you read that one.
Thank you. I will gladly do so. So it was basically like you're saying things that do not jive with what we're trying to do here as an educational institution,
right.
Essentially.
Exactly. And the court, or the trial court at least, kind of says exactly that, where you are promoting a message that is contrary to what message the school wants to promote.
Yeah.
And so the court concludes that Morse, the principal, had the authority, if not the obligation, to stop such messages at a school-sanctioned activity so as to not place the imprimatur of school approval on the message. And I think that's a really dangerous interpretation of Frazier because it essentially gives schools free rein to say what is part of their educational mission and then silence viewpoints they disagree with.
Mm-hmm.
So this goes back to our conversation earlier. Like if Frederick wrote a sign that said no bong hits for Jesus,
this wouldn't be an issue.
This wouldn't be an issue.
Maybe.
And so now we've got like, if you're pro bong hits for Jesus, you can't put the sign up. But if you're anti bong hits for Jesus, you can put the sign up. And, this worries me because it censors speech based on the viewpoint.
And it basically doesn't allow anybody to potentially challenge anything that the school identifies as part of its mission.
As its educational mission, right?
Yeah.
Which would even kind of undermine Tinker too, because, you can imagine a version of Tinker where the school wants to teach patriotism and they see the protest against the Vietnam War as being contrary.
Patriotic.
Yeah, to being anti-patriotic. And so like, and that's something that the Supreme Court will ultimately grapple with is like, how far do we read Bethel versus Frazier? Because there's two ways to think about the school's educational mission and its relation to speech, because we can think about speech that kind of harms the process of education, which is kind of what Tinker did, right? Like Tinker said, if you disrupt the process, that's a problem.
Right.
Bethel versus Frazier seems to be saying, if you disrupt the message of what the school is trying to teach, then that might be a problem.
Right.
And as we'll talk about in a second, courts have been really reluctant to interpret Bethel versus Frazier to be too expansive. But that didn't stop the trial court here, who said that the school could censor Frederick's speech under Bethel versus Frazier.
Okay.
So ultimately, the trial court grants the school defendant's motion for summary judgment.
Okay.
And that's not the end because...
Well, do we really think Frederick is going to be okay with that?
Exactly. Perhaps not surprisingly, Frederick appeals the decision.
We could have called that Frederick was going to try to take this. If he didn't win, he was going all the way.
Exactly. Yeah. So he takes it to the Ninth Circuit and guess what? He wins.
Hey.
Yeah. So the Ninth Circuit, which covers pretty much the entire West Coast and Hawaii and Alaska, the Ninth Circuit comes out the other way. They conclude that while this was a school-sponsored activity, and yes, you could read the banner to express a positive sentiment about marijuana use, Frederick's speech was protected and his rights were clearly established. So Frederick wins.
Well, his rights were clearly established under what? Tinker?
Under Tinker, yeah.
Yeah. So they're using the Tinker standard, and they're basically saying, listen, for speech to be restrained, it's got to cause a disruption. Even though this was a school-sponsored activity, there was no disruption here. So you violated his rights, and they were clearly established.
Exactly right. Yeah. The Ninth Circuit puts it in the Tinker bucket. They say that Bethel versus Frazier only applies to speech that is lewd, indecent, or plainly offensive, which Bong Hits for Jesus isn't.
No.
And so because you couldn't point to a disruption, you lose. We've had Tinker since 1969. Sorry, school district.
So now the school's like, well, hey, we want to get in on this appeal thing, right?
Right. Well, and the last thing I'll say about the Ninth Circuit is they actually kind of question whether or not this sign is actually apolitical. So they say, it's hard to distinguish Bong Hits for Jesus from political speech in the context of a state where referenda regarding marijuana legalization repeatedly occur, and there was a recent controversial state court decision on the topic that had recently issued. So they're kind of saying, even talking about Bong Hits is itself kind of political in this context.
Okay,
so to say this sign is not akin to the political speech of Tinker seems a little disingenuous.
Oh, interesting. Okay.
Yeah. But Jamie, you're exactly right. Frederick took it as far as he could, but now it's the school district's turn.
They didn't want to be left out.
Yep. Which is funny because Frederick lost at every single level up until the Ninth Circuit. But the school district ultimately wins the day. They appeal this to the Supreme Court, and in a 5-4 decision written by Chief Justice Roberts in 2007, so it's already been 5 or 6 years.
5 years, yeah.
The court sides with the school, concluding that Frederick did not have a First Amendment right to wield his Bong Hits for Jesus banner.
Now, it's interesting. This is something that we don't talk about a lot on this show, and I talk about it a lot in my classes, that a lot of times we just focus on what was the outcome of the case, right? Like who won? Because that ends up setting the precedent for the most part, right? For whatever topic we're talking about. But we don't talk a lot about what the circumstances were, like the fact that this was a 5-4 decision, right? We kind of often gloss over that when we talk about Supreme Court decisions, and sometimes we think about them like Well, this is it. The Supreme Court ruled, and this was a violation of the Constitution or whatever the issue is, but it's not always very clear.
Exactly.
And when you've got like a 5-4 decision here, that's evidence of the fact that this is a hard or controversial kind of topic, right?
Yeah, because you can summarize the holding in this case. So we talk about holdings. Those are typically kind of the idea of like the rule of the case, right?
Yeah.
The holding here is that schools can punish or censor student expression that is reasonably interpreted to promote illegal drug use. One sentence, boom. That's the rule from Morse v. Frederick.
Right.
It's obviously a lot more complicated than that because you got to understand why the court adopted that rule and then also how it kind of interplays with these other legal authorities like Tinker and Frazier.
Right.
Yeah. So the majority opinion, which ultimately sides with the school, they look at this and they say, yes, this is school-sponsored. This is a school-sponsored event, and the sign could be viewed as reasonably promoting illegal drug use. So they look at the sign, they say, there's a couple ways to understand this, but it's reasonable to think that someone could look at this and say, yep, that's promoting illegal drug use, which,
okay,
I don't know if I agree with, but I see it, I guess. So, which I guess means that, yeah, it's reasonable.
Okay.
So maybe I talked myself out of my own position. So the court is looking at that incredibly narrow question of whether or not a principle consistent with the First Amendment can restrict student speech at a school event when that speech is reasonably viewed as promoting illegal drug use. And the court says the answer is yes.
Yes.
And so like the trial court did, like the appellate court did, it looks at Tinker and it looks at Bethel versus Frazier, and it kind of starts to figure out what are the rules that we should be applying here. So it reiterates the strong protections that Tinker affords to student speech, especially student speech that touches on matters of politics. And then it does something really interesting, the court's majority opinion. It sort of hedges on what Frazier actually means. To Jamie, to your point earlier, like a lot of the fight here is on how do we understand the rule of Frazier? Like, how do we understand the rule of that case, which said that, yes, you can prohibit lewd and indecent speech. How expansive is that? And how does that relate to Tinker, which said you can't punish student speech unless you've got a material and substantial disruption?
Uh-huh.
So that's why it's so important to kind of dig into these and dig into their logic.
Yeah, totally. Absolutely.
So the court actually says in one of those fun little jabs that they do to each other, the court says, the mode of analysis in Frazier is not entirely clear. So the court kind of says, like, we're not really sure what the court was doing in Frazier, but we've got these two principles that we can distill from Frazier. First is that constitutional rights of students are not coextensive with that of adults. And this is really important because Chief Justice Roberts says if the student in Bethel versus Frazier had delivered the same speech in a public forum outside of the school context, it would have been protected. So that goes to like that importance of the question of, was this a school-sponsored activity? Because that's kind of what ultimately sets the stage for BL versus Mahanoy area schools is if you're not in school, school authority is much weaker and students' rights are much stronger.
Yeah.
And then the second principle they distill from the Frazier case is that it demonstrates that some student speech exists outside of the Tinker analysis. And that's the window that they end up walking through. Door? They end up walking through? That's the door they end up walking through.
Wow.
So they've got this really narrow understanding of Frazier. And so they basically say Frazier recognizes that we can basically carve out new exceptions to Tinker, and they do just that. They carve out an exception for illegal drug use. And that's not necessarily unsurprising given the context of what was going on with the court in 2007.
Yeah.
They had decided a number of student search cases where they'd kind of said that schools have a really
broad authority,
significant, broad authority, a significant, if not compelling justification to curb illegal drug use in schools. They kind of identify this like national pandemic of drug use and all of the harms that that's causing onto students. So like, it's not surprising in that context that the court looks at all of this and says, drugs are such a threat to schools and schools have such a substantial interest in curbing illegal drug use.
Right.
We're going to give them authority to stop speech that would be reasonably viewed as promoting illegal drug use. So they basically create another carve out to the Tinker standard.
And that's what makes it one of the biggest student speech cases, because when we talk about what speech can be restrained, we talk about the disruption standard, right? We talk about, which was Tinker. We talk about the Bethel versus Frazier standard, which is the lewd and offensive The reason why you can't wear, a shirt that says "FU" on it with, the full word, right? Or whatever. Or the reason why you can't stand up and swear up and down school or whatever. And then you've got the Hazelwood versus Kallmeyer standard, which is the sort of the
School-sponsored
speech, right?
Yep.
And then now you've got this other piece, which is pretty much specifically focused on advocating for the use of illegal drugs.
Right.
Which is very specific.
It is very specific, and it's an incredibly narrow decision.
Yeah.
And that, I think, is something really important to recognize here, is to recognize what the court didn't do. So yes, they create this new carve-out exception to tinker.
But what they didn't do was say anything that goes against the educational mission of the school can be restrained. They didn't go that far.
Exactly. Right. They actually reject that argument flat out.
Yeah. And so that should make you very, very happy given your concerns from earlier in the episode, Chris.
Right. Yeah, because the court says that the trial court's interpretation, quote, stretches Frazier too far.
Oh, okay.
So I think, in that regard, I think curbing what people had been doing with Bethel versus Frazier was a really good thing, because it is really problematic when we're starting to allow schools to engage in viewpoint discrimination without kind of being really clear about when and why it can do that, and kind of what are the bounds on its own articulation of its educational goals.
Right.
Which actually leads me to the other opinions in this case. So that was the majority opinion by Chief Justice Roberts, joined by the other 4 conservatives who were on the court at the time. There were a grand total of 4 other opinions. It wouldn't be a Supreme Court case on education unless we had a million opinions.
17 opinions. Yeah. and it is funny because, especially going back to what I said before, sometimes it's a 5-4 decision, but that doesn't mean that all 5 of the people in the majority think the same way about the outcome. And it also doesn't mean that the 4 people in the minority feel the same way or have the same reasoning about why they disagree with that.
Right. Yeah, exactly. And so maybe it's more accurate to say this is a 5-1-3 decision.
Okay.
So we've got the majority opinion joined by the 4 conservative justices.
Okay.
So there's 5 justices in the majority. Of those 5 justices in the majority, we have 2 concurring opinions. Jamie, do you want to guess who wrote the concurring opinions?
I'm going to say, let's see, Alito and Thomas.
Hey, look at that. Yeah, I know we talk about Justice Alito and Justice Thomas a lot.
Even though I know this case,
right.
If I didn't know this case, I think that would have been a reasonable.
It tracks.
Yeah.
Yeah. So Justice Thomas, I don't know if I've said this on the podcast, no relation. He files a concurring opinion. And for Justice Thomas, this was an easy case. He said students didn't have rights when the 14th Amendment was adopted. Therefore, they shouldn't have rights now.
Oh, boy.
I know that's the gist of his argument. And we talked about this when we did Brady Levy versus Mahanoy, because Thomas he dissented in that case too, which is why that case was 8-1 or 7-1 if you want to look at Justice Alito's concurrence. But, he kind of says in the Mahanoy case, maybe circumstances have changed, so maybe we should rethink that, but no one gave me a reason to rethink it, so I'm not going to yet. But this is kind of where Justice Thomas starts to articulate his view that students didn't have speech rights before, so they shouldn't have them now. Luckily, or from my perspective, fortunately, Justice Thomas's ideas have not caught on, and this is not a widely shared perspective. But I do worry, given kind of the Supreme Court's recent pivot to history and tradition on a lot of these constitutional things, because, if you think about when the 14th Amendment was adopted, public schools looked so different than they do today.
Oh, yeah.
All that to say is Justice Thomas might be seeing his ideas might be more influential moving forward. But at least in Morse v. Frederick, he was just writing for himself.
Okay.
Then we've got Justice Alito's concurrence. And I know we like to poke fun at Justice Alito sometimes, but I actually really like his concurrence here.
Okay. All right.
I know. So Justice Alito on student free speech, I think that's where him and I see closest to eye, because he says in his concurring opinion that was joined by Justice Kennedy, he essentially writes to narrow or explain his narrow understanding of the majority's holding. So he doesn't want Morse v. Frederick to be read very expansively. Like, he's saying this is a narrow opinion. So to kind of read from his opinion, he says, quote, "I join the opinion of the court on the understanding that 1, it goes no further than to hold that a public school may restrict speech that a reasonable observer would interpret as advocating illegal drug use," which is the holding. And 2, it provides no support for any restriction of speech that can plausibly be interpreted as commenting on any political or social issue, including speech on issues such as the wisdom of the war on drugs or of legalizing marijuana for medical purposes.
Yeah, so he's basically saying what we've said before, is that he's okay with this decision because it does nothing to restrict the kind of speech that could criticize other aspects of a school's mission or anything like that. Okay.
Yeah.
Okay.
And I think that phrasing, plausibly be interpreted as commenting on, is really important.
Yeah,
because
he's
that casts such a wide net.
Yeah. He's like, I'm cool with this because you're not leaving any room for interpretation here.
Exactly.
Yeah.
And so Alito, he goes on to also say more about why we have to reject the expansive reading of Frazier that the lower court relied on. So he writes that the opinion of the court does not endorse the broad argument advocated by the school that the First Amendment permits school officials to censor any student speech that interferes with the school's educational mission. This argument can easily be manipulated in dangerous ways, and I would reject it before such abuse occurs.
Okay, so he's really driving his point home.
Yeah,
right now.
Because for Alito, he's really worried that you're going to get these elected school boards who are going to adopt educational missions that are like aligned with promoting a preferred political ideology or a preferred social view.
And no one's going to be able to challenge them.
Exactly. And that is a huge problem to the First Amendment and to democracy, because, schools are, as Justice Breyer said in the Brandy Levy versus Mahanoy case, they're the nurseries of democracy, right? They're where students learn their constitutional rights. And so if we don't let people
exercise and experiment and figure it out.
Exactly. Yep. That's going to have really huge implications. So that's where Justice Alito comes out. We've got a concurrence from Justice Breyer, who's actually one of the court's liberals. So he concurs in part and dissents in part. He would have just said, look, the school leader gets qualified immunity. Let's not touch the First Amendment issue because honestly, it's too complicated.
I love it when they do that.
Right.
Like, everybody's been wrestling with this issue and we're struggling so much to figure it out. So it's going to get to this entity that is essentially been established to help us figure these things out.
Whose entire job it is to do that.
That's what it's their job. Like, that's why you're here.
Yeah.
But instead, so often they go, you know what? That's too hard. Let's
or they'll say, like, we can decide that on other grounds. Therefore, we don't need to do
so
the
we don't
hard
have
part.
to wrestle with the hard question.
Exactly. Yeah.
Yeah. Lazy.
Which is what he would have done. And that kind of previews his approach in Mahanoy too, because he writes the majority opinion in Mahanoy. And it's very much a like, I don't necessarily have an answer, but I know this is wrong. Yeah. So that leads us to the final opinion, which is the dissent by Justice Stevens, which is joined by Justices Souter and Justice Ginsburg. And the dissent agrees that the principal shouldn't be held liable for pulling down Frederick's sign. They basically wouldn't have created the constitutional rule that the majority did, that schools can prohibit messages that promote illegal drug use. So they still would have said, like, look, she was probably fine to pull down the sign, but the reason she said she did it, which was this idea about promoting illegal drug use, that's probably not good
enough reason.
Yeah. Or that reason itself would have violated the Constitution, because the court's opinion says, like, you can't justify the school's action based on its desire to silence Frederick's speech, but it says that concerns about a nationwide evaluation of the conduct of the high school's student body would have justified the principal's decision to remove an attention-grabbing 14-foot banner, even if it had merely proclaimed "glaciers melt." So like the school or the dissent is basically saying, like, look, you can't censor it because of the message that he's conveying, but you could do it in a neutral way, a content neutral or, a reasonable time, place and manner restriction, however you want to think about it, that has nothing to do with the message because, hey, maybe we just don't want people holding up 14-foot banners during a school-sponsored activity when there's national cameras there, regardless of what the message says.
Well, but that's interesting. If that was the way this played out, wouldn't that give schools pretty broad authority to restrain lots of different kinds of speech if it just, because it's not a disruption. They weren't talking about a disruption standard. They were talking about we don't think that this is the right place for that.
Right. Well, and schools can regulate students' conduct pretty significantly. Like schools have broad authority to regulate conduct, which is kind of what the majority or the dissent here is saying is.
So it's not about the speech. It's about the speech. It's holding up a 14-foot
exactly.
banner. Okay.
Right.
Okay.
So even if they held up a blank piece of paper that was 14 feet by 3 feet, like the conduct of doing that is the problem.
Right.
Not necessarily the message.
It's not the message that's on it.
Right.
Okay.
Because if it was the message, then that would violate the First Amendment.
Got it. Okay, I see.
And the last thing the dissent says is we're not really sure this even promotes illegal drug use, guys, because I don't know what this means. It's nonsensical. Frederick meant it to be nonsensical. This was an admitted First Amendment experiment.
Right.
So why are we reading into the sign?
Yeah.
And allowing the principal's interpretation of the sign to kind of dictate whether or not it can be censored or not is also super problematic. So
that's interesting.
We typically don't allow speech to be silenced because of the feared consequences or how other people are going to react to the speech.
Right.
So allowing it here seems a little weird. Obviously Tinker is a significant exception to that because Tinker's material and substantial disruption is specifically about the impact of speech, but it's part of kind of larger First Amendment doctrine.
That's cool. So
that's the dissent, but ultimately the Supreme Court sides with the school, finds that Frederick's First Amendment rights were not violated and that the school was entitled, that they didn't violate his rights, so we don't even need to worry about whether or not they get qualified immunity. So they reversed and remanded the Ninth Circuit opinion. It goes back down, and the parties ultimately settle Frederick's remaining claims. Because remember, he brought claims under both the U.S. Constitution and the Alaskan Constitution.
Yeah.
And so in 2008, the parties settle for the grand total of $45,000.
Hey.
And that is the end of the story.
Yeah, I love this case.
It's so much fun.
It's so fun.
Yeah, so it reminds me of something that Justice Breyer actually said in the Mahanoy Area School District case. He says that sometimes it's necessary to protect the superfluous in order to preserve the necessary. So this case is so much fun because it's talking about a student's banner that says Bong Hits for Jesus, right? Which seems so ludicrous. But we had to grapple with that because while that seems really silly, it raises these really important questions of school authority and all of these other things. And the fact that it gets all the way up to the Supreme Court just shows how well designed Frederick's constitutional experiment was.
Yeah, exactly. That I think is one of the great takeaways of this case is it's so silly. What happened here, the message that was on that banner is just so ridiculous, but it allowed us to wrestle with some really hard, interesting topics, or not topics, but, with the limits on speech and authority and everything. And that's what makes this case so cool and so fun. And if you've gotten to this far in the episode, it's about our 2-year anniversary at this point.
Maybe for 2 years we'll do Bethel versus Frazier.
Oh my gosh, yeah.
Though I kind of want to do that one sooner.
I know. We probably will. Will.
Well, there'll be new cases.
Yeah. Well, that's I think that's a good stopping point for today. And homework.
All right. So your homework is to celebrate Chalk and Gavel's 1-year anniversary
by doing what, Chris?
We
can't advocate.
We can't say Bong Hits for Jesus here, can we? No.
In some states, it's perfectly fine.
It's on the ballot here in Florida. By liking, rating, reviewing, subscribing to Chalk and Gavel wherever you get your podcasts. That does a ton to help us continue to grow the show. You can also check out our Patreon at patreon.com/chalkandgavel. Your support means the absolute world to us. And then we've also got our teaching guide up on chalkandgavel.com if you're interested in looking at all the cases that we've done, if you want to use them in your classes or in professional development, or if you just want to share them with a friend.
All right. Sounds good. Well, until next time, listeners, we'll see you in a couple of weeks.